thereto are now open for discussion. Honourable Member Dr. Amme Yajnik, you have 18 minutes.
Thank you, sir, for this opportunity. Sir, as the Honourable Minister pointed out, I have 10 minutes, sir.
You have 18 minutes.
Okay. Thank you, sir. So the Honourable Minister pointed out the statement and object of reasons to bring this bill. So the Parent Act was brought in 1971, and it was brought for the provision of termination of certain pregnancies by a registered medical practitioner. The Act at that time recognized the importance of safe, affordable, accessible abortion services to women who needed these services to terminate pregnancy under certain conditions. It was a progressive legislation at that time in 1971. And 50 years later, this bill comes by way of amendment. We welcome this amendment bill, sir. But, sir, there are certain lacunas or certain loopholes which I would like to bring to your notice, sir. I heard you speak that the bill, while in the Lok Sabha, was sent to a standing committee, and several ministers and inputs from several ministries were taken into account. But I did not find you saying that several stakeholders or those who are directly affected by this bill were heard or their inputs were taken. And that is why I would, in the end, definitely urge you, sir, to send the bill to a select committee so that when we are bringing a progressive legislation by way of an amendment to the bill which is 50 years earlier brought in, we think about bringing dignity to women. In the last portion of the statement of objects and reasons, sir, 2 lines have been written, and they say that the proposed bill is a step forward towards safety and well-being of women and will enlarge the ambit and access of women to safe and legal abortion without compromising on safety and quality of care. The proposal will also ensure dignity, autonomy, confidentiality, and justice for women who need to terminate pregnancy. Sir, I would like to draw your attention to the 2 words which are dignity and justice for women, where I will request you to see that the bill does not become one more act, because when these acts become law, sir, they just spill into the legal arena and then they become devoid of sensitiveness. And that is where the woman is largely affected. So coming back now to the main act, the bill has come pursuant to various writ petitions as mentioned by the Honourable Minister. So there were several petitions filed in the Honourable Apex Court and various high courts of our country. And it is surprising to see that these writ petitions had only one prayer, and they were seeking permission for abortion beyond the time limit given by the Parent Act. And that brings us to one very serious and sensitive concern of this society. Why these writ petitions spilled in the arena of the legal and judicial spaces? Because the girls or the victims or the women who were pregnant either were pregnant because they were rape victims, they were in a situation where they were mentally challenged, or they did not practically know that these girls or these women were pregnant because of lack of poverty or nutrition, because they did not know for 20 weeks that they were pregnant unless the child kicked in the fetus. The fetus became alive. So in that sense, sir, this speaks a lot about what has happened in the last several years, because these women had to go to the courts to knock the doors for justice. Why would such a situation arise? We just can't put this bill in a straitjacket formula that, well, from 12 weeks we have enhanced this to 20 weeks, from 20 to 24, and then at any time of the pregnancy. Because we are dealing with life material here. It is the woman and the fetus. There is a dichotomy because there are two opinions, sir. One opinion is that women should have right to choose. Should have the right to decide for oneself, her own body. And then there's another opinion that, well, the state has to protect the fetus, the life which is given by the Constitution, the right to life. So when these two opinions are there, we need to have a balancing line, because we are talking about life here and we are not talking about some kind of paperwork or some kind of issues that are pertaining to other arenas of society. So society is also a part of this particular bill. So when we talk about giving dignity and justice to women, yes, the bill is a welcome step, but it is not one solution. It does not give a proper, complete solution. And that brings me to what are the amendments that have been brought in the bill. Sir, there are three amendments largely. One is that the 12-week period, that is a gestation time limit, has been increased to 20. So the women who had to go before 12 weeks or within that time frame now can go to the medical practitioner till 20 weeks. The second time slot is 20 weeks to 24 weeks. And there you need the opinion of two doctors. Earlier, for the time limit for 20 weeks, you need opinion of one doctor. But sir, the main issue here is that apart from two doctors, if it is beyond 24 weeks, the pregnant woman or the girl has to go to a medical board. And the medical board has to be manned by a gynecologist, an obstetrician, a radiologist, and a pediatrician. Now, when we are talking about specialist doctors, we also need to look at what our national family health surveys or whether our national doctors number, do they match with the provision of bringing specialist doctors in a medical board? That is the first point regarding this issue. And the second point is whether there should be a state intervention at this particular point of time when a woman is pregnant, is worried about her own life and the life of the fetus and her well-being, and later on, of course, because she lives in a society which considers these things as stigma. We are not talking about this because it's a legal matter, and we do not bring these issues as far as law is concerned. But these are the issues which will ultimately convert into dignity and justice for the woman. Earlier, because of these writ petitions, women had to knock the doors of the court and seek permission that I would like to go for termination of my pregnancy for so and so reasons, and the court had to intervene. So again, if she has to go to the same courts, despite this amended bill, I think we are relegating women to court structures or legal arenas, which should not be at a time when she's pregnant and she's seized with emotional matters, psychological trauma, and other decisions she will have to take. So, sir, that is the issue where the medical board comes in. And for that, sir, I would like to give some three numbers, not numbers, but data. So there is a survey which was the National Health and Family Survey conducted in 2015 and 16, and that shows only 53% of abortions were performed by registered medical doctors. The rest were done by midwives, auxiliary nurses, or DICE, as we call them in villages. So this speaks volumes about our medical professionals and their availability within our country. So this is of 2015-16, where medical practitioners were not there for 100% abortions that took place in the country. So when we talk about a woman going to a medical board with specialist doctors, do we have a complete survey of how many medical practitioners we have in this country? So that is one major issue, sir. But there's another health profile, the National Health Profile of 2017, sir, which indicates that India has a mere 1 million qualified doctors for a population of 1.3 billion people. And these community health centers data from 2015 to 2019 shows a shortage of 81.89% in specialist doctors. Given this situation, given this data of the national surveys and national data banks, it is not a private study report or any international study report which I am quoting here. Of course, I can quote that also because there is a Lancet Global Health Report 2015 which says that 15.6 million abortions that occurred in India in 2015, 78% were outside health facilities. So that brings us to the question also of hospitals, private hospitals, community health centers, and community hospitals, if there are, because 70% of our people still live in rural areas. We may not look at only super specialty hospitals and talk about...
Honorable members, please, let's keep silence.
And so the third issue, sir, of the medical board and the state intervention, why should a woman be relegated to medical boards which we do not know will be manned by the specialist doctors, or whether they have that objectivity of taking a decision. But the most important and tragic part, I would say, is that no time frame for taking decision by this medical board is provided in the bill. So again, if the medical board does not sit, if one of the doctors is not available, or if another member is not available, then this medical board will take endless time to take a decision, and the woman cannot wait because she is beyond 24 weeks, and it is a health hazard for her, and it is a matter of life and death. So what do we do in these kind of situations? So there will be again a resort to going to court that the board is not able to give a timely decision. What is going to happen to this woman? So again, you are relegating to the court structure by way of another writ petition. So let us not go into these rigmarole of procedures. Why should she be relegated to procedures, and why it cannot be as simple and as dignified as a woman can get from the healthcare system? So this was the issue of both the healthcare providers, dearth of it in the country. I showed the two surveys, the third report of the Lancel report showing what is the situation. We know that the community health centers are not manned by doctors. Even paramedicals are not available to give services to women who go there to these centers. But sir, the most important part is that there is no mention of any counselor or social service provider. Sir, in the UPA government, in 2005, we came with the Domestic Violence Act, and we shifted the criminal procedure which a woman had to resort to get redressal for her domestic violence from the criminal courts to a family court so that she can go to the courts with dignity. And that was a major step where women could feel secure within the homes, not fearing that they'll be thrown out, they'll be subject to some violence. So why here the women have to be going to courts or be at the mercy of these boards? Why can't they just take the opinion of medical practitioners? That also shows one more factor, sir, that these medical boards, will they be formed immediately? And the bill says that it will be provided in the rules. Two things will be provided in the rules. Between 20 to 24, when the two doctors will give their opinion for certain categories of women. At that time, the definition will be mentioned in the rules, but it is not in the bill. So again, though the parliament has got the power to legislate on such issues, why should it be delegated to the government when forming rules? So still, when we pass the bill, we do not know which category of women, because it is not defined in the bill. So again, it will come by way of some kind of definition in the rules. And the second thing, sir, that as far as the medical board is concerned, again, that also the rules will provide where, when. So supposing in a remote area, if a young girl is practically a victim of rape or sexual assault, because these days sexual assault and rape has become a part of the vocabulary of the general public. It is also very sad to know that children of earlier than the last decade did not have the word rape in their vocabulary, but today they have. So that shows the stark ugliness of our society. So if that victim has comes to know, because she is in a rural area, if she has to go to the medical board after 24 weeks, sir, and the rule has not provided for the formation of that medical board, whether it is at the state level or the district level, why should she traverse 200 kilometers to get a decision from a group of doctors, medical doctors? Of course, they're specialists, but why should she be going for a decision? So, sir, these are major issues. And the last issue, which is that there is privacy provided to her, that the doctor or the medical practitioner should not disclose the name of the victim who comes, the girl who comes for termination of her pregnancy. And if he discloses, then it will be punishable under the IPC. But, sir, there is a whole doctrine of conflict of laws. When a doctor has a minor who is a victim or a kind of assaulted with some kind of sexual harassment and has ended up being pregnant, and she has to go to the doctor for medical termination of her pregnancy, she will have to, in a way, talk about psychological factors. She will have to think of what is to be done, and that is where, if she is minor, the doctor will have to inform the police that this is a case under POCSO because the person is minor. And if that is to be done, then you are disclosing the name as well as the contents of that particular matter, which is conflict of law. So the doctor, if he divulges the name under because of the POCSO requirement, he will be punishable with fine and imprisonment. If he does not, then he flouts this law. So, sir, there has to be clarity. To bring a law is very easy, sir. To legislate a law is easy. But to think about visualizing what would be the situation 20 years now, 10 years now, and actually what will happen on the ground is it takes a lot of inputs by stakeholders, and that is why I was bringing that which stakeholders have been heard. So talking about these issues and talking about health providers, inadequate numbers, hospitals in community centers, not possible.
Honourable Member, you have 2 minutes. We need to please.
And so, sir, I would like to talk about the concluding part, sir. So, while the current bill is definitely towards the emancipation of women, it does not give the woman the right to make important decisions regarding her own body, regarding her own well-being, and regarding what would happen to, supposing, because that is, the bill is completely silent on this, if the fetus is live. And sometimes it does happen that the doctors are at a dead end to what to do with this kind of situation. So the bill is silent about that. Sir, it also talks about specialist doctors. And to get all these specialist doctors in one place is difficult. So the third point is that when a pregnant woman is talking about her choice, the right to choose, she's talking about, so just one last moment, is talking about her reproductive rights. So that takes me back to a quote in 1919 by Margaret Sanger. She was a social activist and she started voluntarily birth control movement. And she said at that time, no woman can call herself free who does not own and control her body. No woman can call herself free until she can choose consciously about her motherhood. And so, sir, after 100 years, I still feel that if dignity word is used in the statement and object of this particular bill, what is it that imparts dignity? I do not find a single provision in the bill which is imparting dignity and justice to women. I would urge very sincerely to the Honourable Minister, please send it to a select committee. Let all the stakeholders come with all their inputs, both socially and emotionally, in this issue, because it talks about women as a person, a woman. I'm not going on the other issues of Transgender Act, but I think this requires inputs by a select committee. Thank you, sir.
Thank you.